on Channel 4, the local station.
Thank you, Ashley. Local defense attorney Gene Nichols is joining us now from the newsroom. We should, of course, note that he's not involved in this case. Good morning to you, Gene. Thanks for being here. Do appreciate it. I know we were all trying to figure out what do these questions mean, which is why you're certainly here this morning, Gene. Let's start with the first one. Brown responsible for information on her tax forms if she is not the one that filled them out herself. Surprised by that question? What can you glean from it, you know, in terms of what the jury may be thinking?
And I first gleaned that they are paying close attention to the tax counts. As we know, Ronnie Simmons testified that at least on one occasion he signed her taxes. So I think the jury is being very meticulous in looking at each tax count and realizing that at least on one, she didn't sign her taxes. So they are concerned if she didn't sign her taxes, is she subsequently responsible for them? So maybe they are concerned at least with one of the counts. I don't believe he testified that he signed them all, but he did at least testify that he signed at least one of them. So it's curious that they are maybe comparing the two and what she signed and what she didn't sign.
Okay. So that said then, is that a good sign for her defense attorneys or good sign for the prosecution?
If it was me, I would be concerned as the defense attorney, at least for some of the counts, because clearly maybe on one count, it shows that they are concerned that the government didn't prove their case. But since we know that there's not a defense that he signed them all, I think the defense ought to be concerned that on those tax counts, because the suggestion is that maybe she did sign them, maybe she did know what was going on, which could potentially mean guilt on that count.
Well, which is also interesting, just a point is we personally obviously all have to file tax returns, and you know, when I use someone a CPA who does that for me, it's very clear that you are responsible even though someone else prepared it for you. So it's interesting to see what they might be thinking.
I agree. I think we all know that when we have our CPA do it, as long as we sign those returns, and she's still responsible for her own returns no matter who signed them. She's using sort of an excuse that somebody else signed them in order to show that she did not have knowledge, did not have the intent to defraud the IRS, even though her tax return may have been wrong.
Now, I have to tell you, 30 minutes after this juror was replaced, a new one comes on, and then there's all of a sudden a question, and this question involved counts that are 22 through 24, basically the last three. Did that surprise you in terms of the order in which they asked the question?
It surprised me a little bit just because you would have somewhat expected for this jury to begin at square one again, but just because we call count one square one doesn't mean that they are. They may have received the way they received the evidence or what they wanted to look at first. They can look wherever they want to. So for some reason, this jury had already made the decision potentially to look at those counts first. Maybe they thought that there was less evidence. Maybe they had the evidence in front of them. So I'm not necessarily surprised that they were starting maybe from what we would call the middle instead of at the beginning.
But that said, the judge was very clear also, Gene, that, hey, you have a new juror here, the alternate's been brought in, you need to tear up your notes, throw them out, and start all over again. Would that suggest that they did that, asking a question just 30 minutes after this new juror was there?
I would think so. I would think that maybe this was a holdover question. They could have been dealing with this other juror that they were having problems with from before. So it doesn't mean that this was a brand new question. It could have easily been a question that maybe this new juror also had, but it could be a question that one of the old jurors had, and they just hadn't had an opportunity to get to it yet.
And very quickly, too, Gene, I want to get to this other question, the second question. Have to prove beyond a reasonable doubt to convict on mail fraud. Each mail fraud charge, there's several of them, 7, I believe, carries 20 years each. This is a very important question, it sounds like.
I think it's a very important question, and it's a question that I'm sure the defense was very happy to hear, because clearly in that room, they are concerned at least of one of the elements of those mail fraud counts. Presumably that element has to do with either intent or knowledge. The evidence seems to be pretty clear that those checks were written here in Jacksonville, that they were shipped over to Virginia or up to D.C., and for those parts of those elements of those counts, they seem to have the evidence for it. The question's going to be her knowledge, her intent, what she knew, and if the jury is concerned that the government has not proven at least one element of each one of those, it most likely goes to her intent and her knowledge.
Gene Nichols, thank you very much for your perspective this morning. Do appreciate it. And remember, you can, of course, follow all the developments with the trial on our website. You can watch interviews with the former Congresswoman who has always insisted that she's innocent. Just go to newsforjax.com/trial.